So it looks like we still have a number of people that have yet to sign on, but why don't we get started since we have a lot of material to cover this morning. We want to make sure folks can get out on time. Good morning. Welcome to our fall employment law update. I'm Larry Peckus. I'm one of the partners in the Labor Employment and Benefits Group at Wiggin and Dana. And we'll be covering the topics that you can see on the agenda on the screen, beginning with my presentation on certain developments in wage and hour laws, mostly focused on federal law under the Fair Labor Standards Act, but there's been some interesting activity of late, and I'll cover a few items there. Then we're going to discuss COVID-related litigation that has emanated over the past several months. While the pandemic seems to be receding, the litigation that flows from it is ever increasing. We'll talk about some of the more interesting cases in that realm. Then we're going to talk about pay equity and pay transparency. As many of you, I'm sure, are aware, there's been a lot of activity at the state level and the local level, for that matter, dealing with pay equity and pay transparency. And we're going to talk about some of those laws and the implications of those laws. Then for the best part of the day, we're going to take a short break. We'll come back and talk a little bit about traditional labor law and what's going on at the very, very active National Labor Relations Board and where things might be headed for not only union represented employees, but non-union represented employees who also have to be aware of developments under the National Labor Relations Act and how the law is being interpreted and enforced by the current general counsel, a very aggressive general counsel of the National Labor Relations Board. And then we're going to talk about some developments on the restrictive covenants front and at both the federal level and with various states enacting laws that restrict the use of such covenants and the context in which they can be used with respect to certain employees, lower paid employees, and some states are even going farther and not necessarily rendering all restrictive covenants or non-competition covenants unlawful, but severely limiting when they can be used and under what circumstances they can be enforced. So why don't we begin with the wage and hour segment of the program. I'm going to cover a few slides, just touch on 3 or 4 different hot topics, so to speak, under the Fair Labor Standards Act. Beginning with the always vexing question of whether a worker is properly classified as an employee or an independent contractor. So the Department of Labor has been sort of batting around what the proper test is for determining employee status or independent contractor status for many years. And under the previous administration, there's something of a new twist on the analysis that looks at 2 core functions primarily: the nature and degree and control over the work performed by the individual worker and the worker's opportunity for profit and loss. Those have essentially always been factors of the test, what's generally referred to as an economic realities test, as it's been articulated at the agency level and through various courts. The nuance here is that under the current regulation adopted by the prior administration, these 2 factors are not necessarily definitive, but the regulations say is if both of these factors, nature and degree and control over the work, the worker's opportunity for profit and loss, both point to the same classification, then it's almost certain that the person is or should be classified in that way. So if a worker has substantial independence over determining the method and means of performing the services, and it's project oriented, and there's opportunity for profit and loss based on how efficiently the worker performs the tasks, generally speaking, then the independent contractor classification would likely hold up. If the opposite is true, in substantially all cases, then the worker should be classified as an employee. So that was kind of a new twist. Again, these are always factors that courts and agencies looked at. It's just a matter of putting a thumb on the scale as to these 2 factors as opposed to the other factors that courts and agencies look at. So let's see where we stand now. Let's move to the next slide. Again, this is not to say that other factors are irrelevant, just to be clear, under the current test. And these are factors you've probably seen before if you've looked at independent contractor classifications in your workplace. But they're considered secondary considerations. So the amount of skill required for the work, always a factor, currently less important under the DOL's articulation of the independent contractor test. Degree of permanence of the working relationship, which we always consider to be a pretty important factor, is taken on secondary importance. And whether the work is part of an integrated unit of production, again, always considered to be a little more important than maybe it is right now under this test. So these factors really, as a practical matter, only come into play if there's a conflict between the two core factors referenced in the preceding slide. That's when they'll be influential in deciding whether the classification is accurate or not. So let's advance to slide one more. Okay, so a few weeks ago, the Department of Labor issued a proposed new rule. As you probably know, the way the administrative process works with these sort of legislative rules is that the agency puts a proposed rule out there for notice and comment for some period of time, takes in comments from the public. Oftentimes that's entities like the Chamber of Commerce or industry associations, labor unions, lawyers representing plaintiffs. And they take all those in and they actually read them, and there will be many tens of thousands. Oftentimes these are boilerplate comments that are shared among different folks with the same interests, with aligned interests. But they do read them and they do analyze them. They do give them some thought, and they may modify the rule based on certain comments, and they may not. So we're in that process now. And at least according to what the DOL has framed it, the new rule would obviously get rid of the old one, get rid of the two-factor or two primary factors, 5 secondary factors analysis, and kind of go back to where things were with a multi-factor totality of the circumstances analysis without giving undue weight or added weight to any one factor or another. Now, some factors may be more important in the analysis in a given case than others, but it's not a predetermined weighting of one factor or another factor. Next slide, please. Okay. At least according to the DOL, the new rule would revert to the longstanding interpretation of the economic reality factors, make it easier to identify whether someone's an employee or independent contractor. That's open to debate, and of course rescind the 2021 rule. So an interesting issue here is concerns the need for a regulation at all. Those of you who practice in this area or deal with independent contractor questions with some degree of frequency may be aware that essentially every circuit court in the U.S., the courts of appeals, the level just below the Supreme Court, has adopted one variation or another of an economic realities test in the Fair Labor Standards Act context. They're largely similar, but there are nuances that make them variable from one circuit to the next. But they have their own tests. So the question is, whether in a litigation context, for example, will the Department of Labor, once this new rule goes into effect in whatever form it takes, what are they going to do when they get into court? Are they going to advocate for their own rule? Or are they going to honor, consistent with longstanding precedent in many of these circuits, the rule or the test that's in effect in that particular circuit? It seems to me that courts are very unlikely to just accede to the DOL's wishes and adopt their test when they have their own version of the economic realities test that they've been using, again, oftentimes for quite a long period of time. So you wonder whether this whole exercise is just one of futility and kind of pointless, but keep an eye on it. We'll probably see something at the end of the year or early next year with some variation of an economic realities test that focuses on the factors that we're looking at on the screen. Opportunity for profit of loss depending on managerial skill, which essentially refers to how the worker's level of skill and use of that skill affects his economic success or failure in performing the work. So that might look at whether the worker determines or can meaningfully negotiate the charge or the fee for the work provided, whether the worker has the capacity to accept or decline the work, or chooses a procedure for doing the work, or the order in which he or she will do certain projects, whether the worker is engaged in any sort of marketing or advertising, essentially a business of his or her own, and whether the worker can hire others to help complete the project. So those are some of the factors that looked at in that under that particular criteria. The second criteria is investments by the worker and the employer, or the hiring entity, as the case might be, which looks at whether a worker's investment is capital or entrepreneurial in nature, not just talking about basic tools of the job, but investment essentially in a business. The degree of permanence of the work relationship, we, as I said before, we've always considered that to be an important consideration. All of us on the panel have addressed questions from clients about independent contractors, and one of the first questions we asked is, how long has the person been there? How long do you plan for them to be there? And when we hear that it's going to be 5 years or it's indefinite, that usually throws up a red flag. These should be project-oriented assignments with some sort of specific end date, either when the the project is completed, or some period of time. Oftentimes you can use an independent contractor to cover a position while someone is out on a leave, for example. That might be an appropriate designation, but usually we're talking people who are performing projects, some third-party IT specialist that comes in to install some software, or create some sort of a new platform for you to work with. The trades, plumbers, electricians, folks like that are classic examples of independent contractors. Historically, the nature and degree of control has been considered a crucial factor. This basically looks at who sets the schedule, the worker or the employing entity, what level of supervision is involved, how much oversight is there of the work, who provides who has the right to supervise or discipline, and essentially who controls the worker's time, and who controls the nature, the methods, and the means of performing the work. Next slide, please. The next factor is the extent to which the work performed is an integral part of the employer's business. This has become a more crucial factor under a lot of state laws, including in Connecticut. It's one of the ABC factors. So in essence, if the worker is performing functions that are essential to and an integral part of what the business does, then they're more likely to be considered an employee. If the work is not part and parcel of what the company does, then they won't be. So a decent example might be social media advertising. You might outsource that to a third party or an individual consultant to help with the company's social media advertising. Or you might probably do outsource a certain degrees of your auditing and accounting functions. It's not the business you're in, it's a support function. So that's what that particular criteria looks at. And then, of course, skill and initiative. The more highly skilled the worker is, the more likely they are going to be considered an independent contractor. But that is a gross overgeneralization, so be careful with that one. But generally, folks who are unskilled or learn on the job at your company are more likely to be employees. And then there's a seventh catch-all factor that will eventually, I guess, figure out what it means. Any consideration that may be relevant if it's an indicator that someone is in business for themselves or is not. As I mentioned, the proposed rule currently, the current state of the proposed rule is that we're in the notice and comment period. That runs until mid-December, although theoretically it could be extended. Once that period ends, the DOL will digest the comments and either modify the rule as proposed or not. I suspect there won't be any significant changes, largely because what the DOL is doing is just bringing back a rule that had been in place for quite a while and is, quite frankly, fairly consistent with what most circuit courts use under their own economic realities tests, and it's the same basic factors for all intents and purposes, with modest distinctions from one circuit court to another. So let's shift gears a bit and move over to the next slide. In a very interesting and an important case out of the Ninth Circuit Court of Appeals, which covers several states on the West Coast, including California, Washington, Oregon, Arizona. The Court of Appeals looked at a case where employees sued. This is in a call center context, claiming that they didn't actually go on the clock until after they had booted up their computers, and to do that booting up, it took between around 7 and 12 minutes, which was uncompensated time. So they brought a suit to try and capture that time on a collective basis, a class action. And the backdrop for this is, in terms of what's compensable under the Fair Labor Standards Act, employees have to be paid for time spent on their principal activities and any functions that are integral and indispensable to the performance of the employee's principal activities. So you may recall a few years ago, I'm sure we talked about this at one of our programs, the Supreme Court case holding that in the context of an Amazon warehouse, time spent going through security screening and waiting to go through security screening, which could be, as I recall the case, up to about 15 minutes or so, was not compensable because security checks were not an integral and indispensable part of the job being performed by the warehouse workers. Well, this case came to a different conclusion on the somewhat logical reasoning that the employees in the call center can't really do anything. They can't answer the calls, they can't screen calls, they can't allocate calls, they can't see what information they need to engage in the calls without the computer being up and running. So the court concluded that the boot up time, at least, was in fact compensable, and the case went back down to determine how much time that really is, because as you might suspect, there were competing thoughts on that. Time spent shutting down the computer, however, was not considered to be integral and indispensable to the principal activity. It actually ends the principal activity. So the court sent that question down for the lower court to determine whether shutting the computer down was of itself a principal activity, as opposed to looking at it from an integral and indispensable point of view. Kind of hard to imagine how it can be considered that, but we'll see what the court does. So if you have these kind of workers that, as most folks do, work off the computer, whether it's a call center context or not, and they're non-exempt, they're hourly workers or otherwise entitled to overtime pay, then you have to give some consideration to whether this boot up time may be compensable and have to be accounted for, which of course is a challenge in and of itself, because in this case, as probably in many, the timekeeping system is on the computer, and that clock doesn't begin to run until the computer's up and running. So there will be, there's an administrative challenge there to determine a method for capturing that time if it needs to be captured. So that requires some thought and consideration as well. And certainly an argument can be made that perhaps this time is de minimis, and under the Fair Labor Standards Act, de minimis time is not compensable. But the de minimis doctrine has been losing steam over the past few years, because one of the considerations in applying the de minimis doctrine is the difficulty or the challenge of capturing the time. And these days, with the advancements in technology, almost every second can be captured through some means or another. So you don't want to rest on that. But it is a consideration in a litigation context. It might be an argument to pursue, although perhaps not in front of the Ninth Circuit. So let's move to the next slide. So as I'm sure you're aware, in order to qualify for one of the white collar exemptions, in addition to performing the primary duty of the job has to be an exempt function, whether it's executive, administrative, or professional, the employee must also be paid on a salary basis, meaning that there's no variation in the amount paid based on the quality or quantity of the work. And that salary has to be above a certain threshold. That threshold is currently $684 a week, corresponding to $35,568 on an annual basis. Do keep in mind, however, that there could be a higher threshold under state and local law. New York is a good example, which has different, much higher thresholds throughout the state that are somewhat different depending on where you live. As you might suspect, New York City has the highest required salary in order to be qualified, in order to qualify for the exemption, for white collar exemption. So, and the higher threshold will always carry the day. So keep that in mind. But just on the federal level, right now we're at $684 a week. The administration's spring agenda focused on, among other things, a potential proposal to increase that salary. It was increased several years ago. That increase was rejected by a court in Texas, and that we ended up back where we started at $684 a week. But keep an eye on this because that number is certainly going to go up. Probably, I'm guessing, the salary threshold on an annualized basis will probably be in the mid 40s or maybe even as high as 50. It's theoretically possible that there'll be some indexing involved given the stark differences in rates of compensation, salary levels in different parts of the country, but that has not been done thus far and maybe a little too complicated for the Department of Labor to take on. Next slide. All right. So it's not clear when we're going to see this proposal. I was just at a meeting, a CLE event, and one of the speakers was the Solicitor of Labor. Folks tried to get her to give us some insight on that. She wouldn't do it, but I'm suspecting we'll see something probably within the next couple of 3 months in terms of proposal. Again, like with the independent contractor regulation, that will then trigger a notice and comment period. I won't go into effect immediately, and we'll see where that takes us. But you want to keep an eye on that, as you may need to deal with the situation where folks who were properly classified as exempt based on their salary level may no longer be considered exempt once the new level goes into effect. Then you might want to start thinking early about what you're going to do with those folks that fall between that gap. Are you going to increase their salary to the new threshold? Are you going to start paying them overtime, treating them as not exempt? How are we going to deal with that? You're going to have to consider the economic consequences of those decisions, of course. Next slide. So there is one important Fair Labor Standards Act case that's on the Supreme Court's docket for this particular session. It's called Helix Energy Solutions versus Hewitt. It arises out of the oil and gas industry. It deals with the exemption for highly compensated employees, which is an offshoot of the exemption for executive, administrative, and professional employees. It provides a streamlined duties test for workers making over a higher threshold on an annual basis. That threshold is 107,432. And the issue in this case was whether an oil rig supervisor who clearly was highly compensated, in fact, he made $963 a day, which corresponds to about $200,000 a year, but he claimed he wasn't paid on a salary basis. As you recall, the three components of executive, administrative, or professional exemption are a primary duties test, a salary basis test, and a salary amount, or we just talked about, test. The salary basis test, as I mentioned before, requires that an employee be paid the same amount each week, regardless of the quantity or quality of the work performed. There is a particular regulation, however, that does allow for a daily rate, which is how this individual was paid, $963 a day. And that regulation allows for payment on a day rate, so long as the employee is, one, guaranteed to receive at least the minimum weekly required amount paid on a salary basis. That weekly minimum amount is $684 a week. So obviously a number that's below the daily rate here. So you have to be guaranteed to receive at least that amount each week. And there must be a reasonable relationship between the guaranteed amount and the amount actually earned. And according to the Court of Appeals for the Fifth Circuit, sitting in Bonk, meaning the entire all the judges of the circuit, not just the three-judge panel, concluded with some dissenting opinions that the test was not satisfied because the guaranteed weekly amount wasn't there. In fact, the reasonable relationship test would not have been met either, but the court focused on the guaranteed weekly amount. All he was guaranteed was $963 a day. He was not guaranteed any specific amount a week, although, as the court pointed out, that could have been easily accomplished by just multiplying 963 times 5 and saying you're guaranteed to make at least this much, but the employer didn't do that. So this was just really a straightforward application of the plain language of the regulation, which makes me think that the Supreme Court is maybe taking on this case to deal not so much with the issue of whether someone making $200,000 a year or not should necessarily be entitled to overtime pay, but maybe to look at what level of deference should be afforded to agency regulations, which those of you who are Supreme Court followers may know is a pet peeve, in particular of Justice Gorsuch, who thinks that agencies are given way too much deference by the courts, and believes that in most cases the agency should not be afforded that level of deference, and courts should be able to make their own interpretations of the underlying statutes based on the language of the statute and the legislative history and other considerations, and not so much just accede to whatever the agency determines is the proper interpretation. I don't know if that's where they're going to head with this, but otherwise I'm not entirely sure what I would take on. A case like this, which presents somewhat unusual facts. There's not too many day rate workers in the U.S. That sort of pay arrangement is confined largely to the oil and gas industry, from which this case originated. So you want to keep an eye on this. We've looked at the independent contractor regulation. We've just looked at the forthcoming regulation regarding the salary amount for exempt status. Is this case sort of the third part of that trifecta, where the Supreme Court's going to weigh in on how much deference any DOL regulation really warrants, and maybe throw a monkey wrench in the whole thing. So we shall see. I think we're not expecting a decision on that case until sometime in the early part of next year, but it will be interesting to see what the court does with it. But I think that's the end of the wage and hour section. I guess we have one more slide that was just sort of a summary of what's going on with this case. So I did not remember the date, but the case was argued last month. Takes a while to get those decisions. We might get a leaked draft opinion well before that, but I don't think that's the objective of the court. So keep an eye out for that. And then I will turn it over to Caroline. Are you up?
Yes, Mary and I are splitting up this next section on COVID-related litigation. Thanks, Larry.
All right, great, thanks.
I'm Caroline Park. I'm a partner in the Labor, Employment, and Benefits Department. My partner, Mary Gambardella, and I are going to split up this topic, as I mentioned. If you could go to the next slide, I'll give us an overview of the type of topics we're going to cover in this segment. Just thinking back, as traumatizing as it is, to kind of the early and mid part of 2020, as we were starting to grapple with COVID-19, one of the things that people like Mary and I were doing is realizing that, boy, there's going to be employment litigation coming out of this. And we weren't alone in that prediction, obviously. That was something labor employment practitioners everywhere were predicting. That, of course, came to fruition. There's been many complex employment litigation issues and hazards that came out of COVID, ranging from concerns about employee safety to disability accommodation. Obviously, lots and lots of concerns and evaluation around employee vaccination status and compliance with various local orders. You may recall all the controversy and back and forth regarding the status of the OSHA vaccine mandate. We've also seen plenty of claims about what it may mean if an employee's family member becomes ill from COVID when the employee passed it on after contracting it at work. Probably the hottest area, though, has been retaliation claims coming out of employees who are speaking up about COVID-19 related issues when they're talking about perceived deficiencies in their employer's response to COVID, if they have concerns about not feeling safe at work or some inadequacy in the way they think their employer has responded. Those types of speech and activity have definitely been a hotbed of retaliation related complaints. So in some ways, this is still very much an emerging area. Most of these cases are still pending, so we don't exactly know what type of rulings we'll see and how employers are going to fare when the dust settles on all of these. But what we wanted to do for today is take stock on some of the areas where there have been decisions or we've seen early rulings in cases, like, for example, on motions to dismiss, that give us some indication of what claims may be more expensive to litigate because they could survive that initial stage, even if it remains to be seen if an employer could ultimately prevail. And we, of course, also want to give you some just practical advice. These risks continue every day, especially when we think about remote work. That's requests for accommodations like that probably remain the largest area where an employer could have potential exposure for creating claims. A lot of these claims otherwise may arise out of things that have happened already in the last few months or even years. So if we could go to the next slide. This is the chart that told Mary and me we were right. This shows you how many claims have been filed. So this represents March 2021, so about a year into the pandemic to a couple months ago, and we're looking nationwide, separated by type. So employment discrimination, far and away the leader. That's going to include disability discrimination. It will also include religious accommodation claims arising out of vaccine mandates, and sometimes age discrimination complaints. You'll recall that early on, older Americans were identified as a category that may be at a higher risk for contracting COVID or complications from COVID. And we've certainly seen some age discrimination claims arising out of how employers chose to handle the fact that those in the 65 and over, that was one number, but those in the older age category might have been at a higher risk to COVID. You'll see, as I said, that retaliation comes next. That whistleblower activity is really the next area where there's been a lot of activity. Remote work and leave conflicts. This is in some ways a subset of employment discrimination because it is often a disability accommodation question. So you almost might want to combine those two columns together to really understand just how significant the risk of employment discrimination claims coming out of COVID could be. Vaccine, wage and hour, wrongful discharge, unsafe workplace, wrongful death. You see the rest kind of petter out to just a handful. At the very end, you'll see some, for example, Warren Act in early part of the pandemic, lots of businesses were completely shut down and had layoffs that made it difficult to comply with the Warren Act in terms of the 60-day notice requirement. So there certainly is some activity there, but that is not the major category where we see risk. So we'll start with claims regarding working conditions. If we could go to the next slide. When we talk about this, what we're really talking about is employees saying work is not safe for me, or I got COVID at work. And what's important here is that by and large, contracting COVID at work is something that should be covered by state worker compensation laws. Workers' comp, of course, covers work-related injuries. It also covers work-related illnesses, and that includes exposure at work. For those of you in Connecticut, you may recall that it was some time ago now that for a brief period of time, about 3 months in 2020, Governor Lamont implemented an executive order that created a rebuttable presumption that if you were working during that period of time, it was about March through June 2020, and contracted COVID, a rebuttable presumption that you got it at work. And that was in part to recognize that contact tracing and things like that were very kind of in their infancy at that time, and it might otherwise be difficult for an employee to prove where they contracted COVID. So rebuttable presumption that it was work-related. That expired over 2 years ago. So now we're back to the default where, just like with any other workplace injury or illness, it's on the employee to prove that it was work-related. So it's on an employee to prove I contracted COVID at work. Now, over the course of the pandemic, as COVID became more prevalent and community spread became more common, this obviously became more and more difficult. At this point, no one knows where they contract COVID. You have so many exposures at this point that it's very difficult for anyone to prove that they contracted COVID at any particular location. But again, covered by workers' compensation by and large. There is an exception for workers' compensation, which should otherwise be the exclusive remedy for workplace injuries and illnesses. I'm going to focus specifically on Connecticut just because it's relevant to a pending case that I want to tell you a little bit about. But this is generally true for the structures in other states as well. So there's an exception where the employer actually intended to injure the employee, which is called the actual intent standard, or intentionally created a dangerous condition that made the employee's injury substantially certain to occur. So basically, an employer with bad intent who is actually setting out to hurt their employees does not get to benefit from the exclusivity of workers' comp. Fine. What we're seeing though is there's a pending case in Connecticut that Larry and Nicole Dwyer and I are defending, testing this provision as applied to a claim arising out of a COVID-related employee death. The employee contracted COVID early on in May 2020, and his estate has filed a claim alleging that he contracted COVID because the employer was so reckless in its response to COVID that it meets the intentionality standard. So this is a case of first impression. Should be decided sometime in the first half of next year. We're teeing up our summary judgment motion now. But in our view, first of all, it's a factual matter. It's just not true. The employer was taking all the reasonable steps that the rest of you were, trying to follow all of the various guidance that was getting updated constantly, trying to reconcile the differences and what Connecticut was saying and what the CDC was saying and what OSHA was saying and what it meant. And so there's just really no factual evidence that there was any degree of recklessness. But as a matter of law, we think too that this is going to be an interesting test of this exclusivity provision. Next slide, please. So we have a hypothetical here, and we've taken it actually right out of a pending California case. John employee has contracted COVID from an exposure at work. He brought the virus home. His spouse, who's in a high-risk category, has contracted the virus and is ill in the hospital. Do you as the employer face potential liability for the spouse's illness? So if we could go to the next slide. We have one case like this that's actually coming out. Oh no, we can go back. This one actually, the guy had it. These are called take-home COVID cases. Generally, what we're seeing for the cases where rulings have come out is that courts are saying that employers don't owe a duty of care to their employees' families. The other important part here is that the EEOC has said unequivocally in their guidance that having a high-risk family member is not a basis for an accommodation of working remotely or working from home, that the employer has to accommodate the employee's illness, but does not have to accommodate the employee's family member's high-risk status. So this is one example of a pending case, but in a slide or two, I'll show you another couple examples where the court has already ruled in the employer's favor that there is not a duty and there would not be potential liability for the spouse's illness. So if we could go ahead to the next slide. So this one is Kusiemba. Mr. Kusiemba alleged he was exposed to COVID-19 through his work, where his employer knowingly transferred employees from an infected construction site to where he was working and were not following the local safety procedures that were required. So as a result, he was forced to work in close contact with known COVID positive employees. He contracted COVID, he brought it home, and then his wife contracted COVID. If we could go to the next slide. So they filed suit seeking damages against the employer regarding Mrs. Kusiemba's injuries. The lower court dismissed the case and then it was appealed. Now questions have been referred to the California Supreme Court to answer two questions of law. One I just mentioned, do employers owe duties to the households of their employees to prevent the spread of COVID? And are they barred under California state law concept, the derivative injury doctrine? So we'll see. This will be kind of an interesting bellwether in terms of where these claims could go. But there have been, as I mentioned, a couple of rulings that are already in an employer's favor. Next slide, please. So a California Court of Appeals in another case ruled that the derivative injury doctrine does not bar these types of claims. So they rejected the employer's argument. Court ruled that third parties who suffer injuries logically and legally independent of any employee's injuries as a result of the company's negligence do not lose their right to sue, not preempted by workers' comp. Important part here, though, is we're still talking about negligence. So the employee would still have to get, and their family would still have to get over that hurdle of proving negligence. So for those of you who were diligently and reasonably interpreting and applying the applicable guidance regarding COVID practices, have already taken the most significant step to reduce potential exposure or liability on claims like this. We're talking about potential liability once you could establish that the company was actually negligent in their response to COVID-19. Next slide, please. All right, disability discrimination. We're going to touch on this in a few different ways, and Mary's got some specific cases to talk about as well. But we are seeing, of course, that disability-related claims coming out of COVID are very fact-specific, and that means we're getting some inconsistencies in the rulings. So one example is a federal case from Alabama, Brown versus Roanoke Rehab. Brown tested positive for COVID, provided physician's instructions and test results to her employer. She asked for leave due to her test and her symptoms. The employer required a 14-day isolation period, but basically wanted her back on the 13th day. Brown still had COVID symptoms, and the employer subsequently terminated her. She needed more leave beyond that 13 to 14-day period. That survived a motion to dismiss. The court found that under the circumstances, her COVID, now spanning into its potential third week, could qualify as a disability under the ADA. So and we'll talk specifically about long COVID, but this isn't even long COVID necessarily. This is somebody who is symptomatic for 2 going on 3 weeks, and a court indicating that may be enough to prove a disability under the ADA. So that case continues. That's going to be a factual matter for the parties to flesh out now that the case has survived a motion to dismiss. But the court basically reasoned that if she could provide, she had alleged, but if she could provide enough specific facts about the COVID-19 symptoms she was still experiencing, and if they substantially limited a major life activity, then she had successfully stated disability discrimination claim sufficient to survive a motion to dismiss. Next slide, please. Another ruling, though, kind of came to a different conclusion. This came out of another federal court, but this time in Colorado. A district court in Colorado granted summary judgment to an employer whose employee claimed to have been discharged because of exposure to her father's COVID, and then claimed associational discrimination based on her father's illness. The court concluded that his COVID was not a disability, even though he had passed away, because the death was within 15 days. So it's so odd that both of these cases are looking at COVID in that 13, 14, 15-day period of symptoms. This employee was saying her father was disabled because of COVID that he ultimately succumbed to, and was trying to use that COVID illness to establish that she was discriminated against on the basis of a disability of someone she was associated with, and that was not successful. In that case, COVID lasting 15 days, the court did not think was adequate to survive a motion to dismiss as having alleged that somebody had a disabling condition under the ADA. Next slide. The EEOC says long COVID is a disability. It's of course a factual question, right? There's not necessarily a precise clinical definition for what long COVID means. We just know that some people have lingering symptoms, and some people take longer to recover than others. But from the EEOC's perspective, depending on the particular facts, long COVID can absolutely be a disability under the ADA, and you should consider that as well. We have another California case here as an example. This is one where the employer prevailed. The court held that mild and temporary COVID symptoms don't qualify as a disability under state law, but did note that more severe cases could easily qualify. So again, just like with any other medical condition, there's no blanket rule that some medical conditions are automatically considered disabilities under the ADA. It's always a factual analysis as to how the individual employee is substantially limited. Nothing different about COVID. So when you're approaching COVID-related requests from employees, it's probably more conservative and safer to assume that they would be able to establish that they are covered under the ADA. For those of you in Connecticut, you'll probably know that the definition of disability under the Connecticut Fair Employment Practices Act is even easier to meet. Under that definition, I think each and every one of us could say we have a condition that meets the standard and are protected for that reason. So again, you're running a risk if you're going to look at somebody with COVID, especially anybody with lingering symptoms, and say there's no duty to accommodate because they're not disabled. That's a risky path to head down. Next slide, please. All right, Mary, I think this is where I was going to punt it over to you to talk about remote work.
Yep. Good morning, everybody. And so I guess the moral of the story here is that you have to assess these cases like you did pre-COVID with any other disability cases. And we tend to see employers start to get a little bit remiss about getting medical notes and things like that, with these COVID cases being the claimed disability. And Caroline mentioned that a lot of this is unsettled. We don't know how some of these are going to turn out. And there's nothing that employment lawyers love less than to have to tell clients, we don't know. We can use our judgment based on how things were adjudicated before with disability kind of cases, but keep that in mind as we go through some of these cases. And we talk about California, of course, not just because there's litigation there, but because, as everybody knows, things that are adjudicated in the People's Republic of California tend to be a precursor to how things are going to spill over into the middle of the country and then eventually in the East Coast. Telework requests have become, are increasing and are very, very difficult to assess. So when we had the COVID pandemic, there was some EEOC guidance where it was suggested that the EEOC would not hold it against employers because everybody was working remotely, to suggest that employers after the pandemic could not prove undue hardship. So if you've ever had one of these situations before, you know that precedent is sometimes used by the employee to establish, hey, you know, you let this happen before, so it's not an undue hardship for you to allow me to continue. So again, the EEOC had come out with some guidance about that. We won't hold that against you. However, as we've been mentioning, you've got to now reset. All right. So when somebody asks for continued remote work as an accommodation, you have to assess it like you did before. And courts were saying before, telework, depending on the circumstances, can be viewed as a reasonable accommodation. Or if telework is indeed impossible, which is a high standard to meet in some cases, and it's the employer's burden to demonstrate undue hardship. And keep in mind, extra expense is almost never sufficient to constitute undue hardship. You have to be able to prove now that telework, it constitutes an undue hardship for whatever reason. And undue hardship is not, in our view, going to be established when you just say, we just want everybody to come back. So although that may be the case, you want everybody to come back, or at least come back in some hybrid situation, that is not going to be sufficient to constitute undue hardship. So
Can I
let's
just chime in with one point, Mary, before you talk about the specifics? I'm seeing this come up over and over again. The employees saying, what do you mean I can't continue to work? I've been doing it for 2.5 years. I'm doing my job just fine. And when we really dig into it, they're not, but their performance reviews don't reflect that. But there's been some kind of subtle shifts. People are working around the fact that this employee is remote. Somebody who's in office is picking up some particular job duty. The employee is really not doing well at all on some job duty that does require in person. If that's the type of situation that you have, just make sure that the performance assessments reflect it, because otherwise you're kind of stuck with the employee saying, what do you mean? I've been doing my job great remotely. And then we look at the file and sure enough, meets, exceeds, and nothing indicating, no, the job was restructured, maybe not formally, but there were changes here to allow this person to work from home and they're no longer doing the full job.
That's exactly right, Caroline. It's an excellent point, which leads me to my next point, which is performance management becomes equally critical with a remote worker. And hopefully you've been monitoring that, at least during the pandemic, or at least as things started to quiet down in the pandemic, because any telework as a reasonable accommodation can involve you requiring that the individual meet expectations unless they have, as part of their accommodation request, something else that impacts expectations. In any event, now let's look at a couple of pending cases. This one in neighboring Massachusetts, where the court said that the employee had sufficiently pled claims for failure to provide a reasonable accommodation and engage in the interactive process, where the employee with high blood pressure was told he couldn't continue to work from home during the pandemic. Now, high blood pressure is identified maybe as one of the underlying medical conditions that makes an employee more susceptible to serious COVID-19 symptom impact. You have to continue to monitor CDC guidelines, which I will tell you, we all know are ever changing. However, they do identify some of the underlying medical conditions that would be deemed serious enough to expose an employee more to serious COVID-19 impacts. Then there's another one in Illinois where dismissal was also denied in a failure to accommodate claim, where the employee claimed lung dysfunction. Whatever that means, we'll see as the case progresses. And that employee wanted to continue to work remotely even after they had done so for 4 months. And like Caroline said, the employee is claiming, hey, I was doing my job just fine. And so we'll wait to see what happens here. But our sense is the court, again, will analyze these as they did ADA cases and under state law prior to the pandemic. What is lung dysfunction? And I just want to, let's go to the next slide, but let me throw something in here. It's really important not to be lazy, for lack of a better word, about getting medical documentation. And this is a problem that we see with clients all the time, not just during the pandemic, but because an employee says, I have this, I want to keep working home, that does not mean you don't request backup documentation, including if they say I'm tested positive and I can't come back after the normal, whatever that is, 10-day period. So in this case, out of Michigan, there was a denial of an employee's request the employer was a public school. The plaintiff wanted to continue to remote teach, and they allowed a different scenario that the plaintiff could teach from home 3 days a week and virtually, but this is on appeal because the employer sustained their claim that it is an undue hardship to let her teach from home all the time in a public school setting. The kids are back at school. So this may be one of the situations where undue hardship was claimed. It is on appeal, so we'll see what happens. The next one is also on appeal, where the employer was granted summary judgment where the failure to accommodate claim was involved an employee who had to use specialized equipment in the office, and the employer sustained their burden that it would be an undue hardship. You can't work on specialized equipment at home. We have some pending cases with similar scenarios where access, for example, to highly confidential software containing highly confidential information is at issue, and that people are told you have to come back to work because we cannot grant you remote access to this highly confidential information. Can we go to the next slide, please? Now, in this Georgia case from 2021, the employee who was a health and safety manager had a pulmonary condition. It was one of these identified underlying higher risk medical conditions. And early in the pandemic, employees were working remotely 4 days a week. They wanted people to come back in June 2020. And this particular employee said, I want to remote work 2 days a week to reduce the risk. And the employer said, no. And she said others were allowed to do that in her position, and then she was fired. Now, we don't know how this turned out because it was settled. I wish it had been adjudicated, because the one thing that pops out at me is if I'm being told to come back 4 days a week, for example, and I say, well, I'll come back 2 days a week. The question is, how can this employee tolerate the risk for 2 days a week, but they can't tolerate the risk for 4 days a week? Also, the employer is entitled to address certain situations by making other accommodations. You might remember that under the ADA, the courts have routinely held that the employee is not entitled to the exact accommodation of their choice as long as the employer's proffered accommodation meets all of the restrictions of the employee. So for example, with this situation, could the employer have had that employee in a physical workspace with distancing, even on a temporary basis? Could they have the employee work even at a different site? Did they have a different site where there was more distancing? So again, there might be other things that an employer can do to meet the accommodation request. Next slide, please. Now, in this case, a pharmacy tech had asthma. That's also identified as an underlying condition. And the employee wanted to wear a mask and was sent home because the employer did not want him wearing a mask. Now, again, this is under adjudicated. This has not been adjudicated yet. Everybody filed summary judgment. But let me say this about this. If the requested accommodation, in our view, is as simple as I want to put a mask on, and the employer cannot establish why that presents an undue hardship, this case can turn out fairly poorly for the employer. This is not an unreasonable request, particularly with someone who is dealing with the public all the time, dealing with coworkers all the time, has to be in close proximity with the pharmacist and other pharmacy techs. And if the only request was to wear a mask, I would tend to think, I don't know if my partners on the line disagree, I would tend to think that that's something that should have been granted.
It's
So that,
difficult, Mary, I think, to come up with a job that involves duties where it would ever pose a burden for the employee to wear a mask.
yeah, I mean, I'm thinking about it. We're thinking about it. I'm sitting here pondering, but I'm just thinking, of course, you know, there are filings here that are going to develop the facts more specifically, but I can't fathom why this particular request, if this is accurate, was denied with someone with asthma. I also wonder how someone with asthma can breathe well with a mask on all day, every day, but again, remains to be seen. Can we go to the next slide, please? Now, here's another one. These are baristas at coffee shops, people I consider extremely important workers personally. And because they claimed some type of disability and said we'd come, the employer said, not without being vaccinated. So this is an interesting one. I wish it had been adjudicated, but it was settled in May of this year. And our suspicion is the employer was trying to eliminate or at least reduce the liability that we have been talking about. And so this is more of a vaccine mandate. And unless they had a medical note that a doctor said they should not get vaccinated, our assumption is that the employer could impose that requirement because the EEOC was telling employers they can impose that requirement unless one of two possible exceptions were met. One was medically related and the other was a religious exemption. But this was settled, and so we'll leave it at that. The next slide, please.
Before we go to retaliation, I just wanted to note, we included a bunch of those EEOC cases just to also say the EEOC is actively looking for cases here and they are definitely taking them on. So you probably know individuals can go ahead and file their claims, but if something piques the EEOC's interest, it's going to take it on and actually then prosecute the case. That's what happened in these three examples here. So take away from that too, that, the EEOC is looking to make some examples here, either through case law or really sizable settlements that they love to blast all over their website. So the EEOC is looking.
Yeah, and apropos to that, Caroline, the EOC has been pretty active in general with a lot of these systemic kinds of claims. Their budget was beefed up considerably, and so they are very active in a lot of areas of the law. But Caroline is right, particularly in this one, they are hopping on the fallout from the pandemic in as many cases as pique their interest. When we get to retaliation can include claims that you retaliated against the employee for requesting an accommodation or having a disability. And so when we're talking about retaliation for this purpose, that's what we're talking about. But also in terms of the amount of claims, we're seeing it's more than 50% of those filed at the EEOC right now. Now, again, the EEOC, which is the Equal Employment Opportunity Commission, I'm sure most, if not all of you know that, the federal agency, which is in charge of receiving and adjudicating claims at the administrative agency level for the federal government. They tend to look at claims that involve a number of employees, not single plaintiff claims. That's not to say they won't take single plaintiff claims, because as you see, they have been doing that. But it's really important to make sure that management understands that any adverse action following accommodation requests or claims for disability can be the subject of a retaliation claim. So here are the areas. So we're seeing retaliation and whistleblower claims in connection with OSHA topics. So OSHA, as you might recall, issued some extensive guidelines during the pandemic concerning what it considered to be a safe workplace during that pandemic. And there are individuals who are making claims to OSHA or regarding failure to follow OSHA guidelines. Then there's the National Labor Relations Act, which concerns union or collective activity. And we're seeing claims there that some of the employer's decisions constitute chilling of collective activity, where people get together and they decide to proffer allegations. And then the Family Medical Leave Act, of course, if your situation with COVID, if an employee's COVID symptoms qualify them for FMLA protected leave, and it is denied, so you not only get an ADA-based claim, but possibly an FMLA claim. And as Caroline pointed out, and I want to emphasize, under Connecticut state law and various state laws, establishing a protected disability is a lot easier than under the federal ADA. And now that we have Connecticut paid family leave, we would suggest the same, that qualifying under Connecticut paid leave may be easier than qualifying for federal FMLA. But again, you have to be aware that if someone is out claiming long-term COVID symptoms or continued COVID symptoms, like you would with any other illness, send them the FMLA paperwork. And then, of course, the Americans with Disabilities Act that we've been talking about. Next slide, please. So here are the wage and hour type claims that have come out of the pandemic, where employers were asking employees to be screened. So there were employers taking temperatures and so forth. And so we have cases where the employees said, we should be compensated for that time under the FLSA because we're being required to be screened before we get into work, whether we have to put on masks, have our temperature taken, and so forth. One California court said it was not compensable time because it was not integral and indispensable to the employee's principal job. And that's an old standard. And the California court, surprisingly, very pro-employee state, as we all know, said it was not compensable time. So another case in 2022 in another district of California said the opposite. So screenings to prevent outbreaks that would disrupt business operations, and we all know any outbreak disrupts business operations, was compensable time because it was indispensable to the employee's principal duties. Now, these may be very fact-specific cases, rulings, and I would say that Larry mentioned also the de minimis rule, which is basically that even if it's otherwise compensable, if it's de minimis, and we had a class action case some years ago where that rule was applied, where the court said it was something under 7 minutes. Another court says it's under 4 minutes, somebody else. So it depends on where you are, how long it takes to do the screening, what are you actually asking people to do for these pre-shift screenings, and so forth. Next slide. So what's the moral here is that stand by. There are Department of Labor, OSHA, CDC, and other state and local orders. They're slowing down, but they're not stopping yet. There is no time to start loosening up safety protocols. That is not something you should do. And given all the publicity about flu and how the COVID-19 variants are spreading easily and so forth, this is not the time to relax any of these protocols. Keep lines of communication open with your employees. As guidelines change, make sure this communication is given to your employees. Make sure they understand the protocol for advising you of COVID-19 or even influenza positive results. And now a lot of employers are very anxious to get everybody back to work, get everybody back to normal, but keep in mind these requests for continued telework or hybrid remote work have to be analyzed on a case-by-case basis. So with that, we're going to turn you over and we're going to talk about pay equity and transparency.
All right, it is 9:50, so I'm going to get us started with the pay equity and transparency piece of our presentation so that we can stay on track this morning. So I will be discussing pay equity and transparency. Obviously, pay equity is not a new concept. The Equal Pay Act was passed in 1963, but there has been a renewed focus on pay equity, both in terms of advocacy and the litigation we're seeing, and also in terms of state efforts to close the pay gap. So turning first to those state laws, New York City, or local laws in this case, New York City has passed a pay transparency law. I think we touched on it at our last presentation, but it actually took effect a couple of weeks ago, and that law requires employees with 4 or more employees, at least one of whom works in New York City, to disclose minimum and maximum salary ranges in their job advertisements. That's going to include internally posted job advertisements as well as those that are external. And one interesting piece here is that the commission seems to be taking the position that the law is going to apply to fully remote positions, because those positions can be performed in New York City, right? So if you're posting a position that's not actually going to be performed from within the city, or doesn't have to be performed in the office, but it's open to employees who live in New York City, the commission's taking the position that the law does apply to that position, and that you would therefore have to disclose the salary range on that job advertisement. That's something that may be subject to challenge, but because the law just passed, we haven't seen that just yet. Another piece on the New York City law is that it's not required to include commissions, bonuses, or benefits although there has been guidance that those kinds of disclosures are allowed, they're not required to be included in the job posting. Next slide, please. So that was New York City's pay transparency law. New York State also has legislation pending in this area. It's pretty similar. It requires employers to disclose the range of compensation in their job advertisements. Like the city law, it also is purporting to apply to fully remote positions because those jobs can be performed in the state of New York. And so they are taking the position that that's going to bring the position within the law's reach, and that it has to include the salary range there. So this one passed the legislature in June, but it actually has not been signed into law yet. So stay tuned on that. There is sort of a general trend in this area that we're seeing a lot of states pass these kinds of laws. So we expect that this one will ultimately go into effect as well. Next slide, please. So we also wanted to touch on Connecticut's pay transparency law, just as more of a reminder than anything else. That law took effect in October of 2021. So it's been in effect for a little over a year now. And it requires employers to provide applicants with the wage range for the position for which the applicant is applying upon the earlier of either the applicant's request or at the time of making the offer. So if the applicant hasn't requested it up to the point where you're making the offer, that's something that could be included in a written offer. It also applies to employees. So you would be required to disclose to employees the wage range for that employee's position, either at the time of hiring, at the time of a change in the employee's position. So if they're being promoted internally or moved to a different position, you would be required to disclose the wage range at that time, despite them being an employee already, or upon the employee's first request. So the Connecticut law allows employees to approach their employer and ask for the wage range for their position, essentially at any time. There are some differences between the Connecticut law and the New York City law. One of the primary differences is that the Connecticut law only applies to employers within the state. We've received guidance on that. And so you're not going to run into the problem of a fully remote position if you're based in another state, having to disclose it based on Connecticut's law. Disclose the salary range, that is. The other piece that's different from New York City is that if you have commission-based payments or bonuses, those do have to be included in the job advertisement if they are guaranteed. So if there's a guaranteed percentage commission or a guaranteed bonus, then that's something that has to be disclosed in the job advertisement. If it's discretionary, it does not have to be disclosed within the advertisement. In terms of what the actual wage range means for each of these laws, that's something that's still sort of being figured out as we move through them being enacted. New York City has offered some guidance on that and said that it just has to be set in good faith at the time the job is posted. So it's whatever you believe the range could be at the time of the posting. But they have said that the range shouldn't be open-ended, right? So you can't say $20 and up. That wouldn't be consistent, at least with New York City's interpretation of the law. And then there's also a question of how wide can the range be, right? So can you say that the position's range is $50,000 to $200,000? That's still a question that's up for debate. It doesn't have to be extremely narrow, but it does have to be, again, set in good faith. So if you know that you would never pay $200,000 realistically for the position, then that's, time to consider kind of bringing the ceiling down a little bit on the posting. The other thing to consider with these laws in general is how they're going to affect your current employees. So it's sort of a broader implication than just the advertisements itself. There was actually an article in Time Magazine yesterday titled "How to Use New Pay Transparency Laws to Ask Your Boss for That Raise." So be on the lookout for that in how current employees might be using this information. It's likely that if someone sees you're posting an advertisement for their position or a comparable position, they're going to be looking at that range and maybe using it to kind of ground their discussions when asking for a raise, or it might prompt them to approach for a raise if they see that they are making it at the lower end of that range or even below the range that's posted in the job advertisement. So that's something to be aware of when you are formulating the range, is to consider what comparable employees are being paid that are already working at the company. The other thing to be aware of is that Caroline is going to discuss the NLRA and the NLRB after I finish with this segment, but you can't prohibit discussions between employees of their salaries. So these kinds of laws are likely going to prompt some of those discussions among employees, and under the National Labor Relations Act, that kind of activity is protected. So just keep that in mind and make sure that your managers and other employees are aware of that. And there's Caroline.
Yeah, I'll just jump in. That's an area actually where state and federal law address it both. So Connecticut law has explicit protections. It's not lawful for an employer to discipline or terminate an employee for sharing that information. Carve out, of course, for employees who have access to pay information because of their job. So when you're talking about HR people or payroll people who have access to other people's pay information by virtue of their job duties, totally different. But when we're just talking about employees who are sharing among themselves voluntarily pay information, that's something that's becoming increasingly protected under state law, in addition to what Nikki mentioned about being a likely protected concerted activity under the National Labor Relations Act.
Thank you. Next slide, please. All right, so moving into the kinds of litigation that we're seeing. As some of you may know, if you're facing a lawsuit that's alleging discrimination, it's usually handled under what's called the McDonnell-Douglas framework. And under that framework, the plaintiff has to establish their prima facie case of discrimination, right? So they have to prove that they are a member of a protected class, that they suffered an adverse employment action, and that there's some kind of causal connection between their membership in the class and the adverse employment action that gives rise to at least an inference of intentional discrimination. So that definitely applies under Title VII, but there's some question about whether it applies under the Equal Pay Act as well, to litigation under that act. And that's something that we're seeing come up in litigation more often. There are cases like the one cited here where the court has just sort of presumptively applied the McDonnell-Douglas framework in equal pay cases. And under that framework, we have the plaintiff making their prima facie case, and then the burden shifts to the employer to establish a legitimate non-discriminatory reason for a pay disparity. So those could be things like seniority, meritocracy, any legitimate business reason why you might pay one employee more than another. And then under the McDonnell-Douglas framework, the burden would shift back at that point to the plaintiff to demonstrate that the reason the employer has offered is actually just a pretext, something that they're coming up with sort of after the fact to try to justify a disparity that's actually just based on gender or another protected class. Next slide, please. But we're seeing now some cases, including a significant Ninth Circuit case and a Fifth Circuit case, where courts are saying that that third step of the McDonnell-Douglas framework does not apply in equal pay cases. So essentially what that means is that the plaintiff offers their prima facie case, the burden shifts to the employer to offer a legitimate non-business reason for the pay disparity. But after that point, the plaintiff is not required to come back and make a showing of a pretext. And several cases have recently held that that third step doesn't apply in the context of equal pay litigation. Next slide, please. So just on that point, it's something to consider when you are looking at your pay practices, that it might be a little bit easier for employees to prove their equal pay claims than it would previously have been, where courts were assuming that the McDonnell-Douglas framework applied and they had to satisfy that third step of showing a pretext. We're also seeing other kinds of cases where equal pay claims are being litigated. This is just a recent example from the Second Circuit, where a butcher shop employee claimed that she was being paid less than other male employees who were doing the same work. She pointed in particular to some testimony that was offered that employees were hired as sort of general laborers. They were all expected to do any work as needed, and they should therefore be paid equally. Same pay for same work is sort of the whole concept of the Equal Pay Act. But the Second Circuit disagreed. They looked more closely at some of the testimony and saw that there's at least some differentiation between employees based on the tasks that they were performing. And they determined that their pay was commensurate with those tasks. So just something to consider in terms of when you're looking at employees, what tasks are they performing? And can you sort of point to specific tasks that those who are being paid more than others are responsible for, that the other employees who are being paid less are not? And specifically in Connecticut, Connecticut's pay transparency law also amended our Equal Pay Act. So it's now not equal pay for equal work in Connecticut, it's comparable pay for comparable work. So that's a standard just to sort of keep in mind when you're setting salaries as well. Next slide, please. So moving now into some compliance strategies, as we're seeing these cases increase and a renewed focus on equal pay, it's important just to review your compensation policies, make sure that they're clear, document any compensation decisions and your justification for those decisions. So whether you're deciding to pay someone a certain amount based on merit or seniority or education, those are things that you want to be documenting, particularly because allegations of unequal pay can often come up, months or years after someone is hired and that initial pay decision was made. So you want to have that justification documented because the decision makers who made it may not even still be with the company. So documenting those kinds of things is helpful. You also want to educate your decision makers about the concept of unconscious bias. There are lots of trainings that are available for employers to provide to their employees about this concept and how it can affect pay decisions, among other things. So that's one way to sort of train your decision makers so that you don't end up with these pay inequities in the first place. But if you do suspect that you may have some pay inequities in your workplace, you want to be conducting periodic audits, and we'll talk about some of the implications of that in just a second. But you also want to review any upcoming job postings, including your internal postings, for compliance with those pay transparency laws that are intended to try to close some of these pay gaps. And remember that for fully remote positions that are open to New York employees, you want to make sure that you are including those wage ranges so that you aren't running afoul of the New York laws. Next slide, please. So coming back to the audits, they are an important tool and they can be very helpful in identifying pay disparities in the workplace, but there are also some risks associated with pay audits that you just want to be aware of before making the decision to undertake one. So we would recommend that you consult with counsel before conducting any kind of pay audit and understand those legal implications. One of which that's very important is that generally pay audits are going to be discoverable unless you're conducting them under the cloak of attorney-client privilege, right? So if you try to conduct your own audit and you don't engage counsel to do that with you, and you identify that there are pay disparities, and then a lawsuit comes up later where there's an allegation that there are pay disparities, all of that information is potentially discoverable. Mary, I think was going to.
Yeah, I want to jump in here. There's nothing more important than this point. Don't do this unless you're going to fix it. And we have this conversation with a number of our clients who are trying to stay ahead of the game. Auditing, doing market analyses are all very good, but there is a self-critical analysis exception to privilege, but it is not always favored. And Nikki's absolutely right. You have to do it with a lawyer involved at every step of the way. You have to be careful about publication of the results. You have to keep it close to the vest. You have to determine if you're going to hire a vendor to help you, if you have a large employee workforce. And we have to make sure that the contracts with the vendor are overseen and possibly directly with counsel. But that having been said, again, if you're going to do an audit to address wages and compensation equities, then make sure you do something to fix it, because nothing is worse than identifying a problem and you don't fix it. And with litigation, now you're deemed to have intentionality with respect to pay inequity.
Thanks, Mary. And with that helpful emphasis, I think that's the end of this segment. Can we go to the next slide? Yeah. All right. Thank you.
Great.
Turning it over to Caroline.
Thanks, Nikki. All right, so we're going to talk a bit about the resurgence of unions and the Biden NLRB. The NLRB gives us something to talk about basically every time we do one of these seminars. And the past couple times we've met, that's really always been activity by the new general counsel, Jennifer Abruzzo, at the National Labor Relations Board. She has set a very ambitious agenda to enhance employee protections under the NLRA. Just highlighting some of those: regulating and banning captive audience, other mandatory meetings, revising protocols to ensure faster unfair labor practice investigations, greater collaboration in terms of enforcement activities with the Department of Labor, the EEOC, and the DOJ, which can be a surprisingly big deal, and seeking more robust damages for unlawful conduct. So just talking briefly about that enforcement stuff before we move on. For example, if it comes up in an NLRB investigation that there's a classification question, it can potentially be an unfair labor practice under the National Labor Relations Act to misclassify somebody. But this suggests that now you're actually going to kind of guarantee that it's going to make its way to the Department of Labor for the Department of Labor to also investigate the potential misclassification issue for violations, not just of the National Labor Relations Act, but of the Fair Labor Standards Act. So if we could go to the next slide. This is something that just came out within the last couple of weeks. And it's pretty timely, especially when we talk about workforces that are more remote, where electronic monitoring has become even more important when you think about trust and how to ensure that job duties are getting done when you don't have people in your facility in person anymore. The General Counsel issued a memo targeting employers' use of electronic monitoring technologies. So she's using existing board precedent, at least in name, limiting the use of surveillance technology that's going to chill the exercise of employees' Section 7 rights. And now adapting that and taking it a step further to say that she wants the board to find that an employer has presumptively violated the National Labor Relations Act, where the employer's surveillance and management practices would tend to interfere with or prevent a reasonable employee from engaging in activity protected by the NLRA. So this would be a big step. And basically she's using board precedent that dates from a time where all work was in person, and talking about the actual physical surveillance of employees or video cameras or things like that, and cases where the board was assessing, is the presence of that type of surveillance going to prevent employees from engaging in Section 7 rights? And Section 7 rights, no big mystery there. It can be as simple as just employees talking to each other about the terms and conditions of their employment. So take that a step further, adapt it to technology today and to today's workforces. And now what she's talking about is surveillance and electronic monitoring. So for example, tools you might use to screen for like off-topic conversations in online platforms. So if your employees use something like Slack or some other instant message platform or chat platform, this could potentially be covering the type of surveillance or monitoring that you might be using to just make sure that those are being used for work-related purposes. The idea being if that's employees' only real way to connect with each other, and that would otherwise be where they would be sitting and saying, really not happy with management lately, really, pay is not fair, inflation is going up and we're not getting an increase, and they're talking amongst themselves about that. She's looking at systems where is the employer stifling that to such an extent that it's going to interfere with an employee from engaging in activity protected by the act. So this is definitely something to keep an eye on, because this would be an area where she's really seeking to take existing precedent and not only expand it, but apply it in new and different ways to current technology as opposed to the technology that existed at the time the precedent was originally set. Along these lines, she's also got her eyes on precedent regarding employers' ability to regulate employee email. That's been an area where the board flip-flopped a decision issued under the Obama era National Labor Relations Board called Purple Communications, which established that employees have a right to use employer provided email for Section 7 activity, including union organizing. That was reversed under the Trump administration, and you can just guarantee that will go the other way again very soon. Go to the next slide, please. So she does recognize there is some practicality here, that their monitoring does serve a legitimate interest. But her goal is that even where an employer has demonstrated a legitimate business interest in monitoring or surveilling employees' use of technologies, she encourages that the board set a standard where the employer would have to disclose to employees, one, the technologies it uses for monitoring, two, why it's monitoring at all, and three, what it's going to do with the information that it obtains. Next slide, please. All right, captive audience meetings, and I want to talk specifically about this from a Connecticut perspective as well. But first, under the National Labor Relations Act, in this spring, she announced she was going to target this as an enforcement priority. She issued a memo urging the board to reconsider long-standing precedent holding that captive audience meetings are lawful. So what are captive audience meetings? If you don't know, in a union organizing campaign setting, or for example, leading up to a union election, if a campaign gets to that point, a captive audience meeting is basically an employer holding a meeting where attendance is required just to speak to employees, to share the employer's view of the union. And there's lots and lots of guidance about what an employer cannot or can say in that setting lawfully, but generally an employer can express facts. You know, this union charges X dollars in dues, or opinions. I used to be in a union and it didn't work for me, that type of thing. But basically, it's in most campaigns, it's an employer's only true opportunity to speak to their employees about the union and get the employer's view out there. So restricting captive audience meetings really limits the employer's opportunity to share information with employees in a union organizing setting. So these restrictions that Abruzzo is proposing is basically that the board should prohibit employers from holding compulsory meetings at all. So an employer could hold a voluntary meeting, but that means it's just based on whoever's going to show up. Well, who's going to show up? Probably the people that already agree with you. So that's not going to be a very effective tool to get information out to employees in advance of a union election. Her position is basically that, and she's advancing this in a current pending case, that captive audience meetings are inherently unlawful because there's a threat of retaliation, discipline if you refuse to participate or attend because it's a required meeting. If you failed to show up to a required training or a required safety meeting or roll call, there'd be disciplinary penalties. So too, if you failed to show up to a required captive audience meeting, there would be disciplinary penalties. So this would definitely kind of handicap an employer's ability to effectively communicate with employees in a union organizing setting. It's also under attack in some ways in the state of Connecticut. If you could go to the next slide. So Connecticut, for years, many legislative sessions now, there was proposed legislation to, at a state level, make captive audience meetings unlawful. And that didn't pass for several legislative cycles. The former Attorney General Jepsen, he issued an opinion finding that, I think rightly, finding that such legislation is preempted by the National Labor Relations Act. So a state law can't regulate something that is already addressed under federal law. But Attorney General Tong took a different position, and actually ultimately it passed and it went into effect this fall. So under the Connecticut statute, employers can't mandate that employees attend meetings, listen to speech, or view communications, the primary purpose of which is to communicate the employer's opinion regarding religious or political matters. I think 99.9% of you would never ever consider holding a mandatory meeting about a religious matter. But political matters is defined broadly enough to include meetings about the decision to join or support a labor organization. So the words captive audience aren't in the statute, but that is of course what this comes down to. This is already, as of about 2 weeks ago, already subject to challenge. A group of the CBIA and various chambers of commerce have filed a lawsuit seeking to declare the statute unconstitutional, both because it's preempted and on the argument that it violates the employer's free speech rights, that an employer as an entity, as a company, has a right to engage in certain types of free speech, and this statute limits those rights in a way that makes it unconstitutional. So that that case is pending. I think they've got strong arguments. Obviously, I already agree with the preemption one. But even if that case is successful and the Connecticut statute goes away, captive audience meetings are still under pretty strict scrutiny at the federal level from the National Labor Relations Board as well. So a union organizing campaign and responding to it is an incredibly fraught time where you should have counsel no matter what, to help guide your response to the union and help make sure that your communications don't cross a line such that you're going to be accused of committing an unfair labor practice during the course of the campaign or in the days leading up to the election. But certainly with this uncertainty about captive audience campaigns, that's yet another reason to make sure that you're working with counsel if you're dealing with a union that's actively trying to organize your employees. Next slide, please. Just one more note about the Connecticut statute. It's so one-sided. There is no restriction on labor unions. So labor unions, of course, remain free to communicate with employees however they can get to them, basically within the confines of the employer's policies on solicitation and distribution, but free to communicate about the benefits of organizing, whereas employers basically don't have the opportunity to present contrary viewpoints. Next slide, please. All right. This is another area the National Labor Relations Board is looking to broaden the joint employer definition. If you're having a feeling of deja vu, that's because this has happened before. The Obama era National Labor Relations Board also targeted this. Basically, there was a period of time where unionization rates were in decline, and the National Labor Relations Board was very much looking for ways to broaden its coverage, broaden its jurisdiction, and bring more people within its purview, bring more employers within its purview. And one type of working arrangement that it was very focused on were temporary employees. So those employed through staffing agencies and things like that, as well as franchises. And when they were considering those relationships, they're saying, okay, the employee is dealing with the franchisee, the person who owns the franchise, the particular restaurant location or whatever it is, or they're dealing with the staffing agency. But somebody else out there, either the franchisor or the employer where the employee is assigned, is actually the one who dictates the terms and conditions of their employment. And the NLRB wanted to get those people to the bargaining table, so to speak. So their effort in 2015 was in a case called Browning-Ferris, which was broaden this very much so that any entity could be considered a joint employer if it even had indirect or reserved authority that it was not exercising to control one or more terms or conditions of employment. So using the staffing agency or temp agency as an example, because that's so prevalent, if you have temporary employees or employees through a staffing agency that are assigned to your site and you dictate the schedule, you say we need people here 8 to 4, Monday to Friday, that is the type of control over the term and condition of their employment. Doesn't matter to them who administers the payroll, doesn't matter who is the employer of record. Doesn't matter who actually has the authority to discipline or fire them. They're looking for indirect control or even the ability to control one or more terms and conditions of employment. 2020, that was pulled back. The Trump era National Labor Relations Board reversed Browning-Ferris, went back to the pre-2015 standard for joint employment, which required direct and immediate control over essential terms and conditions. So a much more traditional view of joint employment that under really any assessment would be far less likely to pull in companies using staffing agencies and things like that. So this is back in the spotlight again. Next slide, please. This time they're trying to do it by rulemaking, which is a little bit different. In the past, this has changed through by decisions issued by the National Labor Relations Board. The NLRB actually doesn't do that much by rulemaking, but this time they are trying to do it by issuing a regulation that would revert back basically to the Browning-Ferris definition of joint employer. So the same one from under the Obama era board, that much broader view. The proposed language is a party asserting a joint employment relationship may establish joint employer status with evidence of direct and reserved forms of control, so long as those forms of control bear on employees' essential terms and conditions of employment. So this is, sometimes, we start this NLRB segment and I see that, not now, but when we met in person, people kind of check out thinking, I don't have unions, not for me. I'll tune back in a few minutes. This is one of many, many examples of areas where it could have lots of implications for employers with or without unions. Here, both in the context of organizing activity and in the context of potential unfair labor practices, a broader definition of joint employer could mean liability for unfair labor practices, even totally outside the context of organizing. So for example, maintaining overly broad policies that are alleged to restrict an employee's Section 7 rights. Your policy, you didn't update your handbook yet. It still says in there, wages are confidential, employees should not talk about them. Get hit with an unfair labor practice charge saying you're maintaining an unlawful policy. Joint employer is the type of issue where it's going to kind of pull in more, pull in a company into a staffing agency dispute or pull in a franchise to a franchisee dispute. Next slide, please. So under this proposed test, the question is going to be whether they have the right to control, not whether it actually exercises the control. So what they're going to be looking at is, what does your contract say you can do? Does the contract say you have the right to request that the employee be terminated? Does the contract say you have input into their performance review? Does a contract say you can direct the temp agency to discipline them for violations of your policy? Does the contract say that you will have ultimate approval over vacation so that you can control staffing issues? That's what they're going to be looking at, not whether on a day-to-day basis you're actually using those provisions, but whether you have the authority if you wanted to exercise it. And it's also going to be even one essential term or condition. So they're under the former precedent, which was reverted to under the Trump administration, it was a much bigger picture analysis. It was really looking for control over essential terms, plural, or conditions of employment. Here, they're going to be looking for just one. Do you have the right to control even one essential term and condition of employment? Next slide, please. So what's an essential term or condition of employment? Wages, benefits, compensation, hours of work scheduling, hiring and discharge, discipline, health and safety, supervision, assignment, work rules or directions. We often see in the temp agency setting that on site, who is the employee, the individual getting direction from? Usually there's going to be somebody from the employer on site who's responsible for making sure the temps or the staffing agency people are getting work and doing what they need to be doing. That's assignment of work. It's potentially supervision. It's definitely direction regarding manner, means, or method of work performance. So basically the joint employer standard now, once this is codified officially, going to be very, very broad. Next slide, please. All right, the next thing the NLRB is trying to do to really secure the status of unions as a key part of workplaces in America is make it harder for employees to remove a union. So once a union is certified as the representative for employees, generally they're there for a year, but employees have a right to file a decertification petition, and they do happen. There are definitely instances of employees becoming dissatisfied with the way the union is operating, or dues are too expensive as compared to the benefit they're getting. What they're trying to do is make it more difficult by changing the rules around how a union could prevent this. So basically 30% need to be interested in getting rid of the union. And then once the vote happens, at least half must vote to remove the union. If you could go to the next slide. Under their proposal, the union could challenge decertification proceedings by filing a blocking charge, which basically would be an unfair labor practice charge alleging that the employer improperly interfered with or brought about the decertification process. So if an employer is, out there making it known that there's this decertification process and encouraging employees to take advantage of it, for example, that's the type of activity that could give rise to a blocking charge like this, which would prevent the decertification petition from moving forward and keep the union in place as the collective bargaining representative. Next slide, please. This is just one example. The cases are starting to trickle out for sure of the types of reversals and changes in precedent that we're expecting. This one was actually about an union's right to access an asset purchase agreement. So a union in the sale of a context can have rights to bargain over the effects of the sale of a business. And there's all sorts of complicated rules regarding successor liability if you're purchasing a company that has unionized employees. But here, this was actually an order where giving the union access to portions of the asset purchase agreement as relevant to the union's bargaining activities. So if you're in this setting, just be aware of the types of documents the union may be able to get its hands on. Next slide, please. Just one other one. This one actually came out of Tesla. This was about pro-union apparel. So super common to see t-shirts or buttons or things like that in a union organizing setting. The NLRB here basically backpedaled on prior precedent and ruled that prohibiting employees from wearing pro-union apparel violates the National Labor Relations Act. Used to be the case under the Trump era board that employers could restrict employees from wearing union gear while they were working. Next slide, please. Just one kind of final thought we'll leave you with so that we can get and stay on track timing wise is what's going on in terms of trends. For a long time, decades, we saw a precipitous decline in the percentage of unionized employees. That has changed big time. So in the first 9 months of 2022, union representation petitions were up 58%. So the NLRB is thrilled. It's relevant again. It's in the news all the time. Now with many, many cases, the organization of places like Starbucks, Amazon, Chipotle, those efforts are now prolific. And they are highly publicized and very contentious union organizing campaigns with unfair labor practice charges pending in National Labor Relations offices across the country. So all of that publicity is certainly driving interest and increasing the visibility of unions. And I think this will kind of just compound itself, because the more traction that gains and the more that people see, wow, people are really fighting for unions at Starbucks and at Amazon and Chipotle. Why? What is it about it? They're gonna start considering it as well. So I think we'll just see this continue into 2023. Well, I won't go into this in too much detail, but there are just a couple very high level bullets in the materials here for you to just consider, again, at the highest level. If there's a union organizing campaign, how do you respond? The very first thing you need to do is get your supervisors trained. Anything the supervisor says during the course of a unionizing campaign can result in liability for the employer. So if you've got untrained supervisors out there who don't know how to talk to employees in a union campaign, who are out there saying things that are now going to be construed as threats, for example, kind of a big problem. So when you start to see those first signs of organizing, that is really an ideal time to figure out, one, who's going to be considered a supervisor under the National Labor Relations Act, because it's not necessarily about title, and what do they need to know about how to talk to employees in this setting. So again, there's a couple more slides there. Happy to take questions maybe at the end, but for now I'll turn it over to Mary, who's going to talk about restrictive covenants.
Okay, last, and I hope not necessarily the least, we're going to talk a little bit about the trends in legislation and court cases impacting restrictive covenants. So restrictive covenants can include non-competition agreements that prohibit certain activities post-employment, non-solicitation agreements, confidentiality agreements, and so forth. Next slide. So just quickly, there is a trend. So in certain states, there is legislation that's been passed, like in California, there's California again, restricting non-disclosures, non-disparagement agreements that restrict employees' rights to discuss illegal discrimination or other unlawful acts. Those can be included in some of your confidentiality provisions in these restrictive covenants. So you have to check the state you're in and make sure your confidentiality provision does not include any unlawful elements. Nevada, non-competes for hourly employees are banned, and they have limitations otherwise on enforcement of customer non-solicitation agreements. There is generally a public policy in many states where the courts have said there's an overriding public policy favoring customers in free choice of who they use. Next slide, please. Another example is Colorado, where if you violate the non-compete statute, it's a criminal misdemeanor. And so effective August of this year, post-employment restrictive covenants are presumptively void unless conditions are met. The employers must provide a copy of the restrictive covenant before an employee accepts an offer of employment, and out-of-state choice of law and former selection provisions are void. And a bunch of states have compensation thresholds before you can even enforce a non-compete, consideration requirements and garden leave provisions, and we'll talk about that. Now, we're talking about other states for another reason. Let's go to the next slide. So this is one of our neighbors, but with the era of remote work, where you have employees who might be in different states, some of these states are going to hold that their law applies. So we've had a few cases, for example, where an employee is working remotely for a Connecticut-based employer in Massachusetts or New York, and they're going to continue to do remote work in Massachusetts, and their state law could impact the enforceability of restrictive covenants entered into by that employee. So for example, in Massachusetts, and this is I'm 22 okay, so 4 years old now. This law applies to non-competition provisions only, not non-solicitations or confidentiality agreements. But there's some very specific requirements here about presenting it to the employee, the candidate, before employment begins. If after employment has already begun, it must be supported by separate consideration, meaning you have to give them something of value for it. So it's very, very important, even in Connecticut, and we'll touch on this momentarily, not to let an employee start work for any significant period if the job is the consideration for the restrictive covenant. The agreement in Massachusetts must tell the employee they can talk to a lawyer. It has to be 1 year and no longer. And then the rest of this, not be broader than necessary to protect the legitimate interests of the employer. This models many states' parameters of these non-competes and sort of the prior law, which means that the duration and geographic scope and general scope by the terms of the non-competition agreement must be reasonable, not more than necessary to protect the legitimate interests of the employer. Now in Massachusetts, there must be a garden leave provision. A garden leave provision is a period of time where the employee is paid their base salary during the non-competition term. So that generally, garden leave is something that can help enforceability in general in many states. Go to the next slide, please. In New York, right now, there's no non-compete statute. However, the courts require that the duration and scope be reasonable. These are fact-specific analyses. It depends on the job. It depends on what the interests are of the employer with respect to that employee. So for example, we've had many non-compete litigations where judges have looked at who are the relationships the employee had with customers, for example. Is the employer trying to enforce a restrictive covenant that's greater than the scope in which the employee can really harm or cause harm to the employer? At the end of the day, there's a balancing test. Is there undue hardship on the employee? Are you preventing the employee from working in the field in which they are skilled and most marketable? Is there injury to the public, meaning are you, by your non-compete, restricting the public's right to choice? And there's that reasonableness term again. Next slide, please. Now here we are in Connecticut. We don't have a statute yet. They keep introducing it, and it hasn't been passed yet except with respect to physicians, and we'll get to that momentarily. But again, we have to have reasonable terms in terms of the length of the restriction, the geographic scope, and whether or not on a balancing test, the restraint on the employee's ability is not outweighed by the fairness of the protection provided to the employer. And is the public interest interfered with? Next slide. Again, fact specific. What is the field? How narrowly tailored is the non-compete? When you put the duration and the geographical scope together, even if separately they would be considered reasonable, together, are they oppressive? So you'll see, for example, you might be able to get a longer duration if the geographical scope is smaller and vice versa. You'll see restrictions 1 to 5 years enforced. 5 years is unusual, and it only is involved in very unique circumstances. Like, for example, asset sales, where the prior owners are continuing to be employed by the new organization. That's where 5 years we see is generally enforced. And our recommendation is to include that in the asset purchase agreement, which is not an employment agreement, and not just the employment agreement, because these non-competes and employment agreements have much more scrutiny by the courts. Next slide, please. Now, what some employers like to do, and again, remember, if you have remote workers in a variety of states, is they have non-competes where they put Connecticut as the forum where the law will be applied. However, while these forum selection clauses are generally favored, they can be voided if the employee can prove there's no significant relationship to the parties or reasonable basis for the party's choice, and the application of a chosen state law would violate Connecticut public policy, and vice versa. If you're trying to enforce something with a remote employee who's in California, and we've had this, California has an outright prohibition against non-competes, and that is not new. That's been a while. We've had situations where an employee goes to a California-based employer to work in California and had a non-compete with a Connecticut forum selection provision. And the attempt has been made to enforce it in California, where that employee is now residing and working. The California courts have said this violates our public policy, so we will not apply the forum selection clause. Next slide, please. Here's what did pass. It's non-competition agreements in Connecticut where physicians are being restricted post-employment with an entity. And the public policy basis is, of course, patients should have the free choice to pick their physician. So the statute has elements that restrict the ability to restrict a physician post-employment. And here are the elements. They must be necessary to protect a legitimate business interest, reasonable in time, geographical scope, and practice restrictions, and otherwise consistent with public policy. Next slide, please. And here are the other elements to this. 1 year duration cap in a geographic region of more than 15 miles from the primary site. So you can only have a 1 year duration, and the geographical scope cannot be more than 15 miles from where they practice. The difficulty becomes in large facilities where the physician goes from site to site. So that gets tricky. And it's only enforceable if the agreement was made in anticipation as part of ownership or partnership possibility. Okay, so I think, next slide, please. Now, Connecticut is this law is applying to agreements entered into after July 1, 2016, or renewed or amended after that date. Next slide, please. Connecticut is trying again in early 2022. It has not yet passed, and so they are trying to restrict some elements of the non-compete law. Next slide, please. The FTC is also dipping their toes in the pool here, and they may try to regulate non-competes on a federal level. We've certainly heard that the White House is trying to encourage the FTC to consider some rulemaking to restrict the use of non-compete clauses. Next slide. So one size does not fit all, even in Connecticut. So I will tell you, usually getting the job is sufficient consideration. But once the employee is working, if you're trying to get a restrictive covenant signed after, you have to pay or give something else of value. So it could be at promotion time, raise time, or it can be linked to a benefit. Even in Connecticut, the state courts disagree with each other as to whether or not continued employment is adequate consideration. So when you have at-will employment, some of our state courts will say continued employment will suffice as adequate consideration, and some of our state courts say that's not adequate. And so you have to determine whether or not you should provide additional consideration at the time you're having a current employee sign a non-competition agreement or any restrictive covenants. Next slide. So again, if you are a multi-state employer or you now have employees in multiple states, you have to take a look at the non-competes that you're having people sign. And is there something less restrictive, more narrow? The more narrow, the more enforceable. Next slide. Picking the state where you think they will have the most favorable legal applications is not foolproof. Some mandatory forum selection clauses will violate some state laws in certain states, and the courts will always do this fairness and balancing test. So you have to be careful and make sure you get some legal advice about whether or not you should have your template non-compete signed in all situations. Next slide. Again, in some instances, we've seen non-competes where we, after analyzing the employee's role, the employer's industry, where a non-solicitation of customers and employees could suffice. This applies very often with sales personnel and others who have customer relationships that you want to protect. So non-solicitation provisions are more easily enforced because courts have said they are narrow. Now, you can't have a non-solicitation that's so broad that it actually operates to be a non-compete. But again, you should analyze, what do you really need for the protection? Confidentiality agreements can also help with ensuring that you are as narrow as possible with the protection you need. We hear very often, well, this person's going to go here and share information. Well, confidentiality agreements will satisfy that. And when you have garden leave provisions, that's where you have a time during which, after the individual is no longer actively performing services for you, they continue to be inactive employees, and you can continue to pay them during these time periods. And that makes those time periods much more enforceable. Forfeiture for competition provisions, golden handcuffs. Those are provisions where these non-competes can be linked to benefits that are forfeited if someone joins a competitor within a certain period of time. Because they are linked to forfeiture of compensation or benefits, they are more easily enforced. Next slide. All right, liquidated damages. So there are times where clients are tempted to put liquidated damages provisions in these non-competes, which are provisions that advise the court that if there's a breach that's happened, we automatically get a certain amount of damages, because damages may be difficult to prove. Liquidated damages provisions are not favored in many states, and even where they can be enforced, they'll only be enforced if they bear some rational relationship to the actual losses. So when you have a non-compete, non-solicit confidentiality provision, you should also make sure that you include provisions regarding your entitlement to injunctive relief and attorney fee reimbursement. You don't want to be in a situation where you're spending money to enforce a non-compete and you have no right to reimbursement of attorney's fees. Next slide. Okay. The importance of responding quickly to a breach can't be overemphasized. If you're going to go for an injunction, the first thing the court is going to look at is whether or not you delayed. If you unduly delayed in moving on a potential breach, the court can find that you don't really have this emergency, which is part of what you have to establish to get injunctive relief. Treat it as litigation, pending litigation, and the opportunity for a former employee to cross-claim against you. So make sure you preserve documents, preserve emails, and so forth, and circulate your document hold instructions. Very, very important. Next slide. So we have some time left for questions. If no one has questions or wants to listen to questions, you can certainly drop off now. It's 10 minutes to 11. And if anybody has questions, you can put them in the chat or you can unmute. I see none. Thank you all very, very much for your time this morning. We're so happy that you joined us. If you think of any questions after you leave today, please feel free to email any one of us and we'll be happy to answer your questions. Have a wonderful afternoon.
Thanks.
And there's the code for your HR credit.